Please be seated. We have three cases on this afternoon's docket, the first of which has been allocated 30 minutes aside, so it's our intention at the conclusion of the first case to take a 15-minute recess. I believe there'll be some coffee available for you if you'd like over in the Commons. Council, if you're ready, we'll hear excuse me, Spiegel versus School Board of Miami-Dade.
Good afternoon. May it please the Court, my name is Rodolfo Sarando, Jr. I am with Holland and Knight, and along with my partner, Jack McLean, who is here, and Martha Barnett, also from Holland and Knight, we represent the school boards of Miami-Dade, Broward, and Palm Beach County. Also sitting at a council table with me is Ted Doran, who represents Monroe and Volusia County, and also sitting immediately behind us is Larry K. White, who represents the taxpayers, Marilyn Spiegel, and Citizens Coalition for Public Education. Mr. Doran and I will be addressing the Court. We've decided, subject to your approval, to split the time 15 minutes and 15 minutes. I would like to address Your Honors for 10 minutes and reserve 5 minutes for my rebuttal. Mr. Doran has already indicated that he wishes to split it 8 minutes and 7.
Brian, you'll be governed by the lapse time clock.
May it please the Court, we are here on a final judgment entered by the lower court granting the defendants motions for involuntary dismissal or directed verdict, and I sometimes lapse into the directed verdict vernacular, but obviously we're talking about the same thing, and the grant of a summary judgment that they filed on count 2. As concerns counts 1 and 3, there are two problems. Number one, the plaintiffs did in fact present prima facie showings on both counts, and second, and the one that I would like to address first, is the fact that the final judgment really is a document that represents the afterthoughts of defense counsel rather than the independent consideration of the judge. This is an extremely significant point that we make in our brief, and there is case law that addresses the situation, two situations in particular. One, where a trial judge at the conclusion of a proceeding like this says nothing, looks at the winning party and says prepare the order, and having said nothing, 10 days later signs a 35-page order with absolute details on everything, and this has raised appellate eyebrows. And the more egregious situation, which is what we have here, where you have specific oral pronouncements by the trial judge, but the final judgment in no way comports with those oral pronouncements. In this particular case, Your Honors will find the oral pronouncements of the trial judge between pages 602 and 606 as to count 3, and between 659 and 677 as to count 1. It is imperative, in order to understand why and how the judge ruled, to look at what he actually said and how this document does not represent what he said. When judging or when deciding a motion for involuntary dismissal, just as in a directed verdict, you look at whether or not a prima facie case has been made, which is to say that there is substantial competent evidence on the material elements of the causes of action that have been presented to the court, and when viewed in the light most favorable to the plaintiff, there is enough to go forward. I will give you some examples, if I could, of exactly some of the mistakes that the trial judge made in making his oral pronouncements, which indicate that in fact that is not the standard he was applying, but which were cured by a very deftly crafted final judgment, which he then just signed off on. For example, as concerns count 3...
Let me make sure I understand your position. You're saying that the trial judge can say things on the record as to what he intends his findings to be, but then when he reflects on it after the trial is over and the evidence, that if he enters an order which comports with the law and comports with the facts, he can't sign it? Judge, if it's inconsistent with something he may have said at the hearing?
There's case law that speaks to the issue of when a judge makes oral pronouncements and then the final judgment is submitted, he signs it verbatim, exactly as submitted, and it clearly contradicts what he said were the reasons for his ruling, and there is no explanation from the trial judge as to how he has changed his mind, what process he has engaged in changing his mind. And I'm not just saying that, obviously, judges, as a matter of what I believe. There are cases that have been decided by the Supreme Court in Berg-Perlow, which was one such case. I have a case here called Damiani versus Damiani, Taylor versus Malfara, Allred versus State, Ulano versus Anderson. All of them involve cases where the trial judge, now many times it happens, for example, in the criminal arena, where a trial judge will violate a probationer's probation, for example, give reasons, and then the order that he ultimately signs for revocation of probation is nothing like what he says and makes totally different findings. Let me give you, if I might.
The classic case appears to be the family law arena.
I'm sorry?
The family law arena appears to be where a lot of these pop up. When you have oral findings on the record and one counsel prepares a proposed order and there's no opportunity for the other counsel to make comment or prepare their own order. But here, I'm not so sure, having gone back at the record, at least as it relates to the matter you argued in your brief about the trial court's supposedly finding that this was a legislative act and that changing the price index was a legislative act. I'm not sure I could pull that finding out of the record. It seems to me that at one point the trial court in fact said that they did not change substantive law in adopting the price level index as it was given to them by the agency even. So
he did say that, although, again, he was ruling on a motion for involuntary dismissal. And if you look at the way he made those statements, it is clearly his verdict or final judgment that you might expect him to make at the conclusion of the trial. And if you would just bear with me and let me give you an example of what I'm talking about. As concerns count 3, here's what the judge said. Taking the case in the light most favorable to the plaintiffs, which is what I have to do in considering a motion for an involuntary dismissal. Excellent so far. He then concludes the analysis by saying, but there has to be, in my judgment, a clear showing, a clear and convincing showing that the uniformity clause is not being complied with in order for a co-equal branch of government, the judiciary, to tell the legislative branch that they have violated the Constitution in their funding and the funding mechanisms and the laws that they passed. That is not a prima facie analysis. The analysis that he is supposed to be making and the analysis that he gives lip service to it when he begins is, in the light most favorable to the plaintiffs, has there been a prima facie showing? He then goes off in his reasoning and says, I need a clear showing, a clear and convincing showing. That is a totally different standard of proof that is inapplicable to the consideration of a motion for involuntary dismissal, which is why, if you look at the other examples that I'm about to recite to you, the final judgment very craftily avoids repeating them, because that is not the way he was supposed to be looking at it. He very clearly weighs evidence in his analysis. He begins it all by speaking about the separation of powers in the legislative and the executive and the judicial functions. And yet he goes, which is the way one would begin, again, a verdict, the entry of a final judgment at the conclusion of this case, when one is weighing the evidence and making the credibility decisions that need to be made to resolve.
That could be included in a motion to dismiss, could it not? He could talk about separation of powers from the four corners of the complaint without any problem.
He absolutely could, Judge. And again, if I wasn't clear, then allow me to be clear. That is the way he begins the analysis, and if you follow it all of the way through, it is clear that what he is doing is he is weighing the evidence and giving his views on the final product. Let me, if I could just skip ahead. He has, for example, I'm trying to select the clearest ones because I know I'm not going to have time to name them all. In any event, it is a tenet, since it is not defined that both the legislature and Department of Education, this is now his ruling on as to count 1, the motion for involuntary dismissal as to count 1, both the legislature and the Department of Education, their interpretation of it or their definition of it should be given deference by courts unless it is clearly erroneous. And the court, I can't find that it is clearly erroneous, and I can't find that it is clearly erroneous that a wage component or an amenities component for the calculation of the LPLI is not included in the term price level index. Again, these are ultimate issues. These are the ultimate issues of fact in this case. He is using the clearly erroneous standard. The standard is
Let's assume we agree with you. Excuse me for interrupting, but let's assume we agree with you that under Perlow, this was inappropriate. Should we simply send it back for a new final judgment to be entered?
There are three, the case law seems to say that there are three ways to handle it. The court can reverse and remand for a conclusion of the trial. The court can reverse for a new trial, or the court can reverse and remand for a new trial in front of a new judge. And I believe that the third alternative is the adequate one.
In other words, sending it back for the judge to rewrite the final order isn't an option?
Well, Judge, you can. I mean, I don't know what that does for us. I mean, basically, you have a judge
I don't know. I agree with you. I don't know what that does for you.
Who did not, obviously, was looking not at the appropriate standard, and now is simply going to say, okay, counsel, and they'll stand up and say, we rest. Because what he's already done is he's announced his predisposition on how to rule at the end of the case. He's already decided the case. So clearly, I mean, the case law specifically says that in deciding the ultimate verdict, the plaintiffs have the right to have their evidence viewed and considered in the light of the defendant's evidence. At this point, the judge has articulated, basically, if you read the pages that I gave you and you read his oral pronouncements, they are inconsistent with what he ultimately signed, I believe in conflict with the laws in the cases that I just mentioned. And essentially, he's already decided the case. To send it back and say, well, write a new order, basically, he's already decided the case. He's not going to be ruling on the prima facie. I mean, he may pay lip service to it, but he's obviously already decided the case. So I suggest to you that that is not the appropriate resolution here, and the appropriate resolution is to send it back for a new trial.
Counsel, suppose he had said at the conclusion of the trial or prior to entry of the judgment that I made comments upon the record which were not correct statements of the applicable law, the standard I had to apply. I'm now aware of it, that whether or not it states a prima facie case is the issue, and accordingly I enter the following judgment. Is there anything wrong with the judgment then?
I will enter another ruling on the motion for involuntary dismissal. Yes, I believe you have that discretion. I believe that that is within the realm of permissible.
But if he doesn't say that before entry of the order, then you want a trial before a new judge.
Well, I don't know that I'm in a position to know exactly what has to be expected to come out of the judge's mouth. What I'm suggesting to you is that, common sense and life experience guide us in many things, and we don't need cases to say it. And the trial judge sat there for, I guess it was a day and a half or 2 days, listened to the trial, and essentially ruled on the merits, essentially issued his verdict, as it were. And to send it back to him and say, well, you were a little fast on the draw here, Judge. You really kind of have to rule on the basis of the motion for involuntary dismissal. I believe that he's already predisposed. I don't believe that he is going to necessarily be objective on this, which is why I believe it should be done a new trial and before a new judge. I know I don't want to step on my colleagues' times, and I see I already have. So thank you very much. Needless to say, we stand on our brief for the many issues that have been briefed.
Good afternoon, Your Honor. As was previously introduced, my name is Theodore Ardorn. I represent specifically Volusia and Monroe County School Districts in this matter, along with the other appellants being served here by my co-counsel. I hope it will not be lost in this court that 38% of all of the children of the state of Florida who are attending school K through 12 appear before you today in arguing this case. I'm going to take a much different approach. I am not going to talk about procedure unless you direct me to. I'm going to talk about substance. We were specifically denied the ability to seek a remedy under Article 9, Section 1 of the Florida Constitution as it was rewritten in 1998. The trial court, in reaching its decision, rejected on a motion to dismiss our complaint and concluded that based on the Simon versus Celebration case, a Fifth District Court of Appeals case which spoke specifically to educational malpractice, in essence a tort claim, concluded that Article 9, Section 1 was not self-executing. In deference to the trial court judge, we now know that the Bush versus Holmes case has been released by the Florida Supreme Court. It is a mirror image of what we argued down below. Of course, it did not exist at the time Judge Davey made his decision. We believe that the Florida Supreme Court has now ruled on that issue. It is very clear that Article 9, Section 1 is self-executing. It is clear based on the Gray versus Bryant case, and it's also clear based on the NAACP case that this court issued. Actually, Judge Browning, I think you were a concurring opinion on that case. It is presumed that the constitutional provisions are self-executing. Otherwise, it would thwart the will of the people. The will of the people is very clear in this, and Bush versus Holmes on page 406 makes it very specifically a finding that three things have occurred now. One is that this new, after 1998, constitutional provision has created what has been determined by constitutional provision to be a fundamental value of the citizens of the state of Florida. It's also determined there's a paramount duty to provide. Thirdly, and it says specifically in its holding in the Supreme Court decision, Bush versus Holmes, it highlights by italicizing the word how. It says it sets forth how the state is to carry out this educational mandate, specifically adequate provision, and talks about the breakdowns that the court are aware of: uniform, efficient, safe, secure, quality education. We asked for that opportunity. We were denied it. That was error. And we want to go back and we want to present it. What we were forced to do was to present only a uniformity claim. And I'll speak to that in a moment, but let me move on. Then, compound the problem.
In your uniformity claim, how does that differ from an adequacy claim?
Adequacy previously to 1998 was an open-ended question. In 1998, what Bush versus Holmes says and what the Constitution now says is that adequacy is defined. It is defined in 5 ways: safe, secure, efficient, quality education,
but it talks
and
about
uniform.
A system, doesn't it? Doesn't that imply some statewide system? And isn't that what Bush versus Holmes was all about? It was directed at a statewide system.
Your Honor, with all due respect, there's no question that we're going to hear from the opposition here that Bush versus Holmes is a narrow ruling and dealt specifically with a certain aspect of legislation. But if you look at page 406, the Florida Supreme Court has now laid the groundwork for these claims outside of just what was considered in this particular case. And the answer to your question, going back to it, is clearly no. The constitutional provision, as it is set out, allows now for an adequacy claim in the context of these 5 subdivisions. And we were denied the ability to pursue 4 of those. In fact, if you go back in the record, we were ordered not to even use the word adequate. Not in a mean way, but I mean, in effect, the judge says, you will not speak of adequacy, period. Now, what he did was he took 70 years of case law, and you may see that the court initially granted a summary judgment on count 3. And then, after thinking about it, went back, looked at 70 years of case law and said, oh, well, gee, there's all this uniformity case law out there. I can't do this. I'm going to let you bring uniformity. But what he ignored, what he absolutely refused to even acknowledge was that in 1998, all the language changed. I mean, the 70 years of uniformity case law doesn't even address specifically the Article 9, Section 1 as it exists today. And then, on top of it, to compound the problem, we were denied the ability to present our case because we issued subpoenas to legislative staff in an effort to obtain discovery, in an effort to authenticate documents, all of which are in the record, documents which are in the form of emails, letters, and correspondence and the like. and we wanted to authenticate those documents and move them into evidence. Well, zero documents go into evidence. Why? Because we are specifically denied by this trial court the ability to call one single witness who could authenticate the documents on the basis of separation of powers. How can the existence of a memo, which is in the public realm, and all it needs is someone to come in and authenticate it, be the subject of the separation of powers? It can't. And the reason is because the Florida Evidentiary Code under 90.501 specifically provides that it doesn't matter how you put your pants on, you are subject to being deposed, you're subject to subpoena, you're subject to assisting the judicial system in reaching justice and reaching the truth. Now, the question becomes, are there exceptions? No. This court clearly held in the Gerardo case. There are no exceptions for legislative immunity. And this trial court granted absolute legislative immunity. It is irrefutable on the record. He said, you will not ask a question. I said, Your Honor, please, in order to preserve this record, and in consistent with the HRS case, which is the federal court decision, district court decision here in the Northern District, we need to be able to ask the questions. They can object based on their privilege, and then you can consider it. But unless you let us ask the question, how can you possibly rule? Except to rule that there's absolute legislative immunity. And he did. It is not the case. We do not have a speech and debate clause in our Florida Constitution. We and North Carolina are the only two states in the United States who do not have it. You will note that the legislature, in its brief, never mentions the word speech or debate. Never once. They don't choose to even acknowledge that it's an issue. But it is. It is in the HRS case. It was in your case as you wrote it in Gerardo. And the point was that in 1865, we had a speech and debate clause, and in 1868, we didn't. And in every subsequent revision of our Constitution, no speech and debate clause has been reenacted. And without that, this legislature does not have the ability to go to the judicial system for protection under the separation of powers. Not for what we wanted. We were not, and there's a lot of time spent in the legislature's brief talking about motive and intent. Well, go back and look at the trial court record. We specifically said, Your Honor, we do not want that. We know, we acknowledge that line of cases. We are not asking to go there. What we are asking to do is to prove our case and to prove it through simple questions that do not violate those rules. Now, all that having been said, it is our view that this, aside from these constitutional violations, this trial court failed to do its job by simply rendering a verdict for us pursuant to 1011.62, a literal reading of the statute. A literal reading of this statute tells you that it is the Department of Education, the commissioner, who is to make the decisions on the FPLI. And we have FPLIPs and FPLIAs. We have amenities-based and we have price-based. They are not apples and oranges. They are apples and bread. They are so different. Amenities have nothing to do with price. Amenities are two professors sitting down and deciding that because you have a beach, somehow people will work for you for less money. Well, the problem with amenities is it's regional. It's not specific. You live in Seminole County, you buy gas in Seminole County, the cost of gas in Seminole County is important. You live in Volusia County, and gas is important. But if you want to go to the beach, you live in Seminole County, it's 15 minutes away. You don't care. So if you make more money in Seminole County, especially when you have no discretionary spending like these teachers at $32,000 a year, you just drive to the beach. And we can't compete.
Counsel, you're getting well into the time you wanted to reserve for
Yes, sir.
rebuttal.
All right. Thank you, Your Honor.
May it please the court, Daniel Brown for the the appellees, and at council table with Mr. Klosnick from the Department of Legal Affairs. I will start, if I might, by addressing Mr. Soriano's first argument concerning the trial judge's bench comments compared to the final judgment. I would direct the court specifically to page 674 of the last volume of the transcript, in which counsel at trial for the appellants, Mr. McClain, was engaged in a colloquy with the court over what the court's intent in his rulings were. And Mr. McClain was attempting to get the court to say that the court had found, on the evidence that they presented, it was sufficient to conclude that the legislature, not the executive branch, had made the decision as to what the shape of this index would be in 2004. And here is what the judge said in response to that question by Mr. McClain. Let me be clear about that. I am not finding that they, meaning the legislature, by the Appropriations Act, changed substantive law. I don't think they did. Now, he clearly found from the bench that they had not put on a case that the legislature had, through the Appropriations Act, made any change whatsoever in the substantive law of this state, and specifically what the index to be used for the DCD would be in this particular year. Why would he say that? He would say that because the record is absolutely clear that that did not happen. The plaintiffs admit in their own complaint, and I would refer the court to paragraph 28 of their complaint, quote, the Appropriations Act does not on its face express an intent to change the meaning of the FPLI. That's the allegation of the plaintiffs and appellants in this case. We have given the court as an appendix to our brief the pertinent pages of the House and Senate journals in question, which adopted the joint conference report, which became the Appropriations Act. And for instance, at page 1344 of the House journal, there is a passage which says the DCD shall be computed in accordance with 1011.62 paren 2. There was not only no dispute about evidence in the record as to whether the legislature had changed anything in the Appropriations Act or not. The evidence was absolutely clear that that had not happened.
Well, I guess, at least to me, what's a little bit confusing is the statute appears to contemplate that the DOE would compute the index. And it doesn't appear to contemplate multiple indices being prepared and one being selected in the appropriations process. Now, that starts inching its way, it seems to me, towards the legislature making a decision, while at the same time, of course, the indices were prepared by the DOE.
And let me address that concern, Your Honor. The evidence is quite clear in this record that the sequence of events was as follows. In March of 2004, the Department of Education published the FPLI report. That was in March, while the legislature was in session. Now, that's what the statute requires. It requires a published report, and it requires the Department of Education to calculate the DCD. That was done in March of 2004. There were, in fact, 4 indices discussed in that FPLI report, as the court correctly notes. However, the University of Florida economists, who have been charged every year for approximately 10 years with preparing this index, put in their report that you, Department of Education, or whoever wants to do it, may use any of these indices. But if you wish, in our judgment, to measure accurately what the FPLI is intended to measure, you should use the low centrality wage-based index, which they call FPLI-AS, as I recall from the record. Now, when that happened, these University of Florida economists came before the court, before the legislature. They were in the well of the House of the legislature and questioned at length about why they made that recommendation. The Senate did the same, and neither the Senate nor the House chose the option which they maintained in 1011.62, the opening paragraph, to override what the FPLI would look like if that index were used. What the FEFP would look like if that index were used in the DCD formula. No one in the appellant's corner has mentioned the introductory paragraph of 1011.62. But it says, if the allocation of the Florida Education Finance Program to each district is not determined in the Annual Appropriations Act, then it shall be determined as follows. And then it lists the FEFP formula from step 1 all the way down through step 10 or 12, about third or fourth of which is the DCD and the FPY. The legislation is quite clear that if the legislature wishes to, in any year it may override and choose to do something different than what its experts are recommending to it if it wants to do so in the Appropriations Act. The legislature did not do so. They chose to let the recommendation stand. That is not commanding the use of a formula in the Appropriations Act. And as the trial court pointed out, accepting and appropriating in light of the recommendation is not the same thing as commanding that one use it. They have their facts exactly backwards. The record shows that the recommendation was made first, and then the appropriation, accepting that recommendation, followed, which is what happens every single year. As the record points out, the FPLI has never been a fixed and static index. It has been changed in various ways to try to achieve better accuracy since its inception. And at its inception, it was conceded that it was experimental to begin with. It is an index which is smoothed and changed each year to try to get a more accurate read on concededly what it is to measure. And what it is to measure is the relative difference in prices to hire labor, the cost of labor from county to county. Now, they claim that they made a prima facie case. That's the next point that Mr. Serrano makes. But in fact, if you look at the record, they did not. And here's why. They completely ignore this court's decision in Island Harbor, which is as close to being on point as you could get factually, which sets out the standard their evidence had to meet. Yes, it is a black letter law that you must, in fact, give them the benefit of the doubt in their evidence. But you have to measure that evidence against the appropriate substantive standard in the law. And as this court clearly pointed out, when it comes to an undefined scientific technical term in a statute, the legislature has intended to defer the choice of that technical matter to the agency which is responsible for implementing that statute. And the agency's decision, even if doesn't meet the Frye test of generally accepted by the very scientific community, if it is reasonable, if it is not arbitrary, and if it falls fairly within a permissible construction of the statute's terms, is to be approved. Their evidence had to show not merely that this evidence was not Frye tested, because as this court pointed out in Island Harbor, Frye test is not the rule. It's not the substantive standard by which the trial court or this court was to measure the quality of their prima facie case. Instead, they had to show that this index was arbitrary or outside the terms of the statute. I urge the court, if you have any question at all about this, to examine carefully the only evidence they put on in that regard, which was their expert, Dr. Ashenfelter, an economist. Dr. Ashenfelter said in his testimony, this index is a commodity price index. It is not a retail price index, but it is a commodity price index. He said, he conceded the statute does not require a retail price index. He conceded that as he read the statute, the FPLI's purpose was to measure the cost of the differential cost of hiring personnel, wages. He said it wasn't generally accepted, but he also said he could not say this was economically unsound, not sensible. He might have had some questions about the techniques that they used. His judgment might have been different. But this gentleman, their best shot, claiming this was somehow economic voodoo, refused to say that. They had no evidence whatsoever from their own economists that this index is arbitrary or irrational. And there is no evidence that is outside the plain permissible interpretation of what this statute is supposed to get at. With respect to the trial judge's comments, he was saying, and I think if the record is fairly read, you haven't shown me that kind of evidence. You've only come in here and said, you show me that one economist doesn't particularly think that this approach or that piece of this index is the way he would do it. But as this court said in Island Harbor, the opinion of one economist or a couple of economists that they would have done it differently is insufficient to overcome the substantive standard, which is deference to the agency's interpretation if within the bounds of the statute. So I submit to you the trial court was eminently correct in granting a directed verdict, essentially, at the close of their case on counts 1 and 2.
Even though the language was used was not couched in terms of your evidence doesn't constitute a prima facie case, that would, I call it the Chevron test, because I recognize that's the federal test.
Your Honor, I believe that there's no rule of law that requires a judge to use a choice of words that someone might consider magic. You have to look at what the evidence was presented to him and ask the substantive question, did he, in fact, apply the correct substantive benchmark, yardstick, to the evidence that the plaintiffs presented? And the answer is, I think, fairly clear that he did, because they offered no evidence that this was an economically unsound, economically impermissible index method. And in fact, their own economists couldn't say that this might not, in fact, be a better way to measure what the FDLI is supposed to get at than what had been used for 35 years. And our economists, who they put on the stand, said, we went to this index because the databases and the economic regression tools now available to us allow us to do this. It was unavailable before. Now, with respect to the comments by Mr. Doran, if I might, let me first address his claim that the trial court incorrectly dismissed their claim of constitutional inadequacy. I respectfully submit to the court that that argument wholly misses the mark. As we point out in our answer brief, there has never been a claim by any of the school boards in this case, and I would be interested to see if they make that claim for the first time on rebuttal, because I've never heard it before. And if they do, I hope the court will ask them about it with some probing questions. There's never been a claim that the pie, the amount of money appropriated for the statewide system, is insufficient or constitutionally inadequate. They don't make that claim. They make the claim instead that the pie has not been sliced appropriately, either not uniformly under the Constitution, or not consistent with how they read the statute, or by an index they don't think has been proven up. But they claim the slices of the pie are not right, and therefore, in their slice of the pie, is inadequate. Now, as we point out in our brief, this constitutional article is self-executing in allowing someone to claim against the state a violation of the state-level duty.
But why is it not self-executing with respect to a claim that a particular county, the slice of pie provided the particular county is so inadequate that it falls below a level that could be considered adequate? The language used by, I think, Justice Overton in the Coalition versus Childs case.
I'm familiar with that, Your Honor.
Well, at least that's a standard that was recognized even before Bush v. Holmes. Why isn't that standard at least here?
Because it's simply a uniformity claim at the district level dressed up in inadequacy language. The point is, school boards conceitedly have the right to say, you're not giving me enough money, either because you didn't appropriate a big enough pie, and therefore my slice, while being all right, it's fairly distributed, isn't big enough because the pie's not big enough. They have the right to bring that claim. They have the right to say, the pie's big enough, but my slice is not big enough. That's a uniformity claim. That's not a funding adequacy claim. And there's a clear demarcation and distinction in the constitutional text between uniformity and high-quality education and the other things that Mr. Doran mentioned. What we urge upon you is that there is no claim of the type they now say they want to bring, which they didn't articulate below, which is a claim that an inadequacy claim can result from disuniformity. Well, if that's the case, they put on their best case for disuniformity, and the court found it wanting. If that was wanting, then how could they have an adequate claim based upon that disuniformity if one existed at all? But we submit to you that it doesn't for the reasons we cited in the brief. You can only bring a claim against the state for a state-level duty. And the state-level duty is two things. Make adequate provision for a safe, secure, high-quality education for the system. That's the statewide system. And divide it up uniformly. Those are the two state-level duties.
But the provision also says that the system must, quote, allow students to obtain a high-quality education. It seems to me if a county could put on a case that said, as a result of our slice of the pie, our students cannot obtain a high-quality education, whatever that means.
The problem with that, again, Your Honor, conceptually, when you parse and try to give meaning to this constitutional article is that you can't construe, as Bush versus Holmes points out, you can't construe this article in a vacuum. You have to construe it in conjunction with the related constitutional provisions. And as we point out in our brief, the school boards are constitutionally entitled to run their own school systems and to administer their own funding within their system. The question of whether or not an individual student is receiving an adequate education has as much to do with how they administer and husband the dollars out of the state system they get as to how the dollars are divided up. So they cannot very well say that simply because they claim that their students can't get a high-quality education, that's a default in the state-level duty because they have a co-equal responsibility for it.
Well, they could say it. Isn't that become a matter of proof?
And they had no proof of that, Your Honor. They offered evidence. Their only evidence of this was that they were having difficulty in recruiting teachers in some of these counties. And they say it was because of the high cost of land values. That was the evidence they put on at trial. And that was the evidence they prosecuted at trial that was not admitted. The problem is none of their witnesses ever said, we cannot meet the curriculum requirements and provide the education to our students in this fiscal year that the state requires with the amount of money that's allocated to us this year. No one said that. I urge you to look carefully at the witnesses' testimony. They never said that. They said we had difficulty recruiting teachers and retaining teachers. And later on, if things don't change, if we don't get a different result later, we might have to cut music and other programs. They never said they can't deliver a high-quality education with the dollars they were given that year. There's nothing on the record to that effect. What they tried to do was to simply give you one side of the story, and the trial judge realized that. The question is not whether they received less money, because they did receive slightly less compared to what they would have received under the old methodology. But as Mr. Dorn reminded you, he represents 38% of the students in the state. I stand here, if you take his analogy, representing the other 62% of the students in this state. And the legislature and DOE every year have to make a decision as to how to fairly and equitably allocate the educational dollars that are appropriated. The only thing they said to you is, we have less money than we had last year. But to prevail on their new theory that their slice is too small, they have to show you something more than that. They have to show you that the index method, which is what was responsible for the slicing, is arbitrary or irrational. So even if you said they had some conceptual claim of this nature, it is necessarily grounded in their challenge to the index method. And their case on the index method wholly failed. There is somewhat, I believe, of revisionist history going on with respect to Mr. Dorn's second argument, which is about the courts not allowing them to take the depositions of certain legislative staffers. He said to the trial judge, and it's in their briefs and their response to the legislature's motion to quash, that the reason they wanted to take these depositions was to find out who made the decision about the index and when. That was their basis for wanting to take these depositions at the trial level. the court clearly said, I understand there is no absolute legislative immunity here, but relying upon cases such as the Cheney case, which we cited in our brief, the Nixon case, which we cited in our brief, the decisions of this court and the Florida Supreme Court, the trial judge simply said, you may question the Department of Education about that, and you have available to you the records of the legislature as to what they did and when they did it. But I'm to be cautious about a civil litigant's demand to take broad depositions of the staff of the legislature because of comity with a co-equal branch and separation of powers. That's what his ruling says. He never said, I'm granting this motion because the legislature has absolute immunity. In fact, he recognized that they did not. He recognized this court's Gerardo opinion. So I suggest to the court that none of the bases that they submit to you are borne out by the record. And the claim that they had a inadequacy separated from uniformity cause of action as a district school board for funding is simply not the law. Bush versus Holmes doesn't say that. Bush v. Holmes never gets close to a funding question at the county level. It simply says the state owes a duty to the system, the statewide system, and letting state dollars be appropriated for private education instead of the public system, referring to the state, is wrong. Never said that there's a funding adequacy claim by the county at a county district level, separate from a claim that the pie was not sliced fairly, which is the claim they made and tried and lost. Or a claim they didn't make, and can only make for the first time in a rebuttal in this case, if they make it at all, that the whole pie was not big enough, and that's why they don't have enough money. So I suggest to the court that the trial court, although he could have been more precise in his terminology, clearly applied the right standards to the counts that they brought forward for trial. And there's no reason to suggest, as Mr. Sarando does, that this judge is incapable of making a fair decision. Should you remand it? You shouldn't remand it. You should affirm it. But what else will we put on? We'll put our expert on to say, again, here's how we did this index and here's why. They had their best shot at trying to poke holes in this index, and their economists refused to go there. So I submit to the court that the trial court was correct. And you'll note that they never mentioned, not one time in their brief, not one time below, not one time during this argument, this court's decision in Island Harbor, which says if that index is not arbitrary and is within a fair reading of the statute, which their own expert conceded, then you had no choice but to affirm the trial court. And I'll yield the rest of my time, Your Honor, unless you have questions.
Thank you, counsel. We'll accommodate you as close as we can, up to 7 minutes, but you're well into it. Now, your co-counsel also had 5 reserved, so.
Yes, sir. He's yielded his time to me, so I'm just.
Be cogent.
I will attempt to do that, although there is very much, as you can see, to discuss. Let me say that it seems like Mr. Brown and I tried 2 different cases. I think the record speaks for itself. I encourage you to read the record. Mr. Brown is quick to say, well, you found nothing arbitrary. Well, let me cite the court to Plaintiff's Exhibit number 72, because in Plaintiff's Exhibit number 72, which is an email which we threaded through a needle from an evidentiary standpoint to get into evidence, because we couldn't authenticate all the other emails because we couldn't have access to the people who could authenticate them. You will find that Dr. Denslow, who is their expert, is very specifically saying, well, it's not perfect, but it is data-based and it's not arbitrary, but Monroe is a problem. And you may wish to instruct us to find a reasonable workaround specific to Monroe. And they didn't. And I would contend to this court that this document alone establishes that Monroe County is a county and a district in the state of Florida that, as we speak, is under a disuniform system. Monroe County, and back to your question, which I had lost your train of thought, and I'm sorry I didn't respond to it the last time you asked. It is not about a statewide system. It is about a piece of the system potentially. Mr. Brown's absolutely right. We do not contend and have never contended that this is about more pie. This is about a circumstance where 67 counties are dividing a pie, and let's take hypothetically a scenario where the methodology used and the formula that comes up with the
Let me stop you right there before I lose my train of thought.
Sure.
Mr. Brown has stated that you had a chance to bring in your expert to show it was arbitrary, capricious, or something to that effect, and he wouldn't go there. Now, if your expert won't go there, if his statement is true, what's the problem here? What are we missing? Did your expert agree or would not contradict their expert and their formula and what was happening?
We, Volusia Monroe, did not call an expert. Dr. Ashenfelter was called by the other party. It is our contention that if you look at the evidence in the record, that it is clear that Monroe County is operating, as we speak, in a context that is disuniform. They have a 30% turnaround annually. Every 3 years, Monroe County has to completely rehire their entire staff. They presently raise money through a millage rate unique to them to fund their own school district. Because the state, and you want to talk about using his word, state-level duty, well, the state has a duty to educate these kids. And they're not. And Monroe County, in order to try to compete with all these other districts, has raised $500,000 on their own citizens to augment their educational funding in order to try and retain these teachers, and it still is not working. And all of that is in the testimony through Randy Acevedo. That is the reality on the ground in Monroe County. And Monroe County is a disuniform district. There are 9,000 kids, as we speak, in the state of Florida who are presently operating under an unconstitutional methodology or distribution of funds, causing them to be disuniform. It is desperate. That's not my word, it's his. In the record, the superintendent said, we are desperate. We don't know what to do. Things are going to have to be cut. We cited in the statute the Sunshine State Standards. Remember, the St. John's criteria here are every child should be given an equal opportunity to meet the mandates of the state legislature. Well, the state legislature has mandated through the Sunshine State Standards many things: phys ed, arts, social studies, math, English, science, and the like. Many of those programs are going to be cut in Monroe County. It's in the record. Because the DCD took away the very little thing that they had to hang on to. 11-point swing between Duval and Monroe County. 11%. 11%. They're trying to compete for teachers that can go to Duval County and make 11% more right off the top without even considering the fact that in the record it's established that Monroe County has that the least expensive livable home at that time was $350,000. They can't do it. Now, this expert was called, and I want to take you back to the statute. Mr. Brown says, well, gee, their expert said, well, input, price index, all the other stuff. No. Look at my closing argument. Look at my opening statement. Look at my brief. My brief is clear. Unless you're prepared to overrule the Florida Supreme Court or conclude, I see you smiling, or conclude, you might want to try it a couple times, or conclude that this term, price level index, is not understandable. It's in Webster's dictionary. Price index is in Webster's dictionary. It's in the MIT dictionary. There was no further analysis that was necessary for this trial court to do. 30 seconds. No further analysis. It's there. It's over. It doesn't matter about experts. We don't need, that trial court judge didn't need anybody to tell him what a price index was, and this legislature imputed a wage index, which clearly in the record is something apples to bread. There's no comparison. Amenities versus prices.
One last question that worries me a little bit. You're talking about these documents, you couldn't get them and all these type of things.
Yes, sir.
Did you try any, maybe I missed something in all this record here to help me. Did you try any request for admissions and authentication of documents and this type of thing in advance of trial so you wouldn't need to have to subpoena and go through these things? Because it seems like the trial judge was giving comity to the legislature saying you can get it another way. I'm not going to make you do the most, I don't know, the hard way or the most invasive way, maybe would be the word.
Your Honor, I appreciate the question, but, I know that you've been around the block just as I have. Requests for admissions weren't going to work, and the law doesn't require us to engage in a futile act. We had memos that were coming directly from the Senate and or emails and the like, and they were fighting us tooth and nail on all of that. They were never going to admit that all those things were authentic, and so, no, we didn't try it, but if I had to do it over, quite frankly, I wouldn't.
You wouldn't do it if you had a chance to do it again? Okay.
Yeah. Thank you, Your Honor.
We'll take a recess for 15 minutes.